Hello, everyone. Thank you for joining us today. I'm Marche, the webinar director here at Advice Chaser. Before we introduce our guests and get started, I do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we are thrilled to bring you today's educational presentation. Attendees are muted, but we do encourage you to ask questions using the chat box. The presenters will answer those queries during or after the webinar today as appropriate. We do have a question and answer period at the end. If you ask a question in the chat box and we're not able to get to it, go ahead and leave your contact information as well. We'll make sure someone reaches out to you after today's event to address that. We want this experience to be as educational as possible. So again, please don't hesitate to reach out and ask for clarification or expansion of the material as appropriate. I'd love to introduce you to today's panelists. Our moderator today is David Eads. He's the founder of Vital Investment Management and holds the designation of Certified Financial Planning Professional. Since he was 8 years old, Dave has had an affection for investments, which started with a fourth grade stock picking project at his elementary school. Dave possesses extensive experience in tactical investment strategies, comprehensive financial planning, and tailored retirement planning. Having spent many years in the investment industry, he can devise unique strategies to manage his clients' investments and personal finances effectively. Dave also works very hard to create a mutually beneficial and long-term relationship with his clients and their families. Dave is in the Northern Colorado area, but serves people throughout the country. Will Byers is our presenter today. And he's a native of Northern Colorado, and his practice focuses on estate planning, elder law, special needs planning, and Medicaid and VA issues. Will is licensed to practice in Colorado and has been accredited by the Department of Veterans Affairs to handle VA claims. Will is a member of the Colorado Bar Association, Elder Council, Wealth Council, the Larimer County Trust and Estate Section, and the Larimer County Young Lawyers Association. His monthly columns on elder law issues can be found in the Larimer County and Weld County editions of 50 Plus magazine. And outside the office, Will is an avid Colorado Avalanche fan who loves getting outdoors with his wife and his family. So we're excited to have you both here today. And I'm going to go ahead and turn over the time to you, Will, and get us started.
All right. Well, thank you for the for the introduction. And so we are, today the focus is really estate planning. Both from the proactive and the reactive side of what you can do, what you should do if you or a loved one is faced with really what tends to be long-term care costs that result in medical debts. And so the plan is really to kind of approach today's presentation from the standpoint of there's the pre side of it. So kind of what you can do as you are engaging in estate planning, how you can position yourself well, position your family members well, make things as efficient, as easy as possible. But then we'll also certainly look at it from the standpoint of, I have a lot of clients who are kind of thrown into the fire and all of a sudden they are the live-in caregiver for a parent, or a spouse is all of a sudden they're the caregiver for their husband or wife. And then just kind of wrapping it up, I figured I would give kind of some overarching principles, kind of some general approaches, because Medicaid is certainly something that we will be talking about during this, as that is a frequent topic of conversation anytime that long-term care is involved. And so I'm a big fan of kind of letting the crowd often clue us in on what's the hot topics and what they would like to see discussed. So please feel free to submit any questions that you have throughout the presentation to the chat box, and we will certainly do our best to address those. So estate planning, elder law planning, as it's often called, really that the bones of elder law is going to be a functional, well drafted and frequently updated, or at least frequently reviewed estate plan. And so what does estate plan tend to include? Well, traditionally it's going to be wills or a trust, and then certainly financial powers of attorney, healthcare powers of attorney, and something that we may end up diving into a little bit if we have time. Going back to the trust, sometimes there is there's a good reason to utilize irrevocable trusts when there are long-term care and Medicaid or medical concerns in general. And so really kind of what the I guess the structure of the estate plan provides is really who's going to be in that administrative role, whether you are incapacitated or at your eventual demise, really. And so looking at it from the standpoint of, I've yet to meet the person who says that I would much rather my life's work go to pay for a long-term care facility than go to my next of kin. And so certainly a crucial component of this elder law and estate planning realm is how to deal with the specter of long-term care or assisted living, really any situation where there's an element of nursing care or oversight, and that can take many forms, which we will explore a little bit as we go on. But as far as that long-term care, whether it's a nursing home, whether it's moving into assisted living, there are a lot of different mechanisms that people can pay for that. And so long-term care insurance, that is a classic one. And if you have a great long-term care policy, certainly hold on to it or at least review it. They seem to be becoming a little less available. Retirement funds, those are another big pot to dip into, usually as far as needing additional care for you or your spouse. Income. Now, obviously, that's a little bit different in the elder law realm, as many of my clients who are facing this scenario tend to have minimal income because they're retired. And so a lot of times it's going to be Social Security or annuities or some other vehicles that their financial professionals have put together for them. Assets. So whether that is encumbering assets, getting loans on the assets, or liquidating the assets, because of the cost of long-term care, that is frequently an option as far as how you're going to pay for these extensive bills. And this is something that Marche brought up that I'm glad she did. Medicare does not cover long-term care. And so when we're talking about Medicaid and when we're talking about Medicare, I think it's kind of crucial to start with the reality that Medicaid and Medicare, they are federal programs. So the U.S. government, at the top, they are all aware, the rules are the same. However, the implementation is different from state to state, and even in some cases from county to county. So while we can certainly talk in absolutes about the general rules, I was joking with Marche and Dave a little bit ago that if I went 2 hours up the road in Colorado, I may see a couple different things as far as how Medicare and Medicaid would treat that payment for long-term care. And so kind of fast forwarding to the next step in the life cycle, what do things look like after there is a death? Well, this is almost always going to be dictated by what the family makeup is. If there's a surviving spouse, well, then there's obviously that concern of how are they going to survive? Because if they have had to pay $9,000, $10,000 a month because their husband had very aggressive dementia and they had to utilize an Alzheimer's wing, not only is that a tough situation for anyone to be in the first place, but there's also kind of that back end of, well, mom's still alive. How is she going to continue to pay her bills and pay for her groceries? And, and then certainly a secondary effect of having to deal with long-term care when you haven't prepared adequately is that any money that you wanted to leave to the kids or the grandkids or whoever, that's likely going to be pretty depleted if you have a lengthy stay or require quite a bit of care prior to death. So those are really two components that are they need to be addressed if you're looking at a holistic approach of how to ensure that, I always look at it as really two prongs. Number one, we always want to ensure that whoever it is that we're dealing with, that they're able to get the highest level of care that they're able to get. But they will be the first ones to tell me as well that if there's any way to ensure that they're still able to leave behind what they intended to leave behind for their kids or their spouse or their grandkids, we certainly want to do our best to keep that in place as well. And so that's really where doing thorough good planning in advance is going to be the difference maker as far as these types of situations. So I'm often asked by a wide spectrum of clients kind of what I think is the first thing that a person should do as far as estate planning. It can, if you're coming into the process completely new to it, I can tell you, do not put off having the conversation. Do not put off reaching out to an attorney, because I have people come into my office who are far more intelligent than I am and saying, oh, well, I was a longtime engineer and I was so busy with my work that I never did an estate plan and I'm embarrassed about it. Do not be embarrassed about it. My wife and I have been talking about updating our stuff for the last 6 months, and I could literally draft it. So do not let that be a barrier to getting in and talking to somebody about starting to get a plan in place, because I think that the most crucial document that anybody, regardless of their life circumstances, regardless of their age, should have are comprehensive financial and healthcare powers of attorney. So what those are is, we were just talking about death. Death is very black and white. I mean, it's either a yes or no. It's that case of incapacity that is really, really difficult to navigate. And it gets exponentially more difficult if you do not have these financial powers of attorney, these healthcare powers of attorney in place. Because what those do is those are the documents that are, legally recognized, legally effective documents that indicate to a third party, if you're unable to communicate, who it is that you want to make decisions for you. So that can happen in the healthcare realm. If somebody is, they're in a car wreck and all of a sudden there's 2 routes they could go as far as treatment. If you don't have a healthcare power of attorney in place, theoretically what they're supposed to do and what, is kind of dependent on the provider. But if there's no documentation in place as far as who your decision maker is, they are most likely going to tell you that you have to go to court. The family's going to have to go to court and get some sort of court order to relay that decision-making authority. And so I really, if there's one thing that you come away with that would benefit you, not only in this realm, but also just in general, and we could spend a whole time talking about this on another webinar, but please, if there's anything you can do to kind of proactively put yourself in a good situation, it is to regularly update your powers of attorney. Because if you do not do that, you are looking at a guardianship or a conservatorship if something happens. And that is a nearly impossible door to close once it's opened. So kind of following on that note, what I frequently tell clients of mine is that with the Medicaid planning, if you have good documents in place, or long-term care planning, if you have an attorney, you're meeting with them every couple of years, reviewing your estate plan, you're probably going to, there's probably not anything additionally that you'll need to do right away, assuming that you and your spouse are in good health. And so what I always tell people is that if there is a marked decline, if there is any change in that, in the cognitive ability, because we all begin to slowly decline in our faculties as we get older in age. I mean, that's just the biological reality. And so I always tell people that if somebody starts to decline, that's really, you shouldn't be scared about it as if, like you need to run to the attorney's office, but you certainly should reach out and let them know, because there's still a lot of things that we can do if somebody's on that earlier stage of a mental decline, where we can still get a lot of things in place. There's still a lot of things that we can do, and don't think that you're completely out of luck or that there's nothing that can be done if you received an Alzheimer's diagnosis. That does not mean that you cannot do estate planning, that you're kind of locked into whatever you have, because there are a lot of things that we can do. And really our definition for capacity is different than the legal realm or the healthcare realm's requirements. And so, my final kind of thought on that, on this section really is just that I think that the best, really just to ensure that you're spending your money well on, legal fees, is just to make sure that that whoever it is that you're engaging, whoever it is that you're dealing with, kind of as you start out on this path, is just to ensure that they have a background in the long-term care component. I mean, not to speak ill of my sector, but I think just as there is in any job, there are some people who dabble, and as many of you may know, the potential costs with not adequately addressing this long-term care planning component, it is exponentially more than you would pay for a good attorney, and then some. So just make sure, and again, if you're reaching out to attorneys, you're kind of interviewing attorneys, if you will, ask questions. I mean, they need to sell themselves to you. And so you should just make sure that you're asking questions and that you feel comfortable that they're going to be able to adequately address whatever your concerns are. So Medicaid. So what is Medicaid, and what is it not? So Medicaid is the federal program that is essentially deemed a payer of last resort. And so every single time one of us gets a paycheck, or we pay our quarterly taxes, or however we do that, we are paying into the Medicaid system and the Social Security system. And so the way that it's set up is that there are certain requirements, once they are met, that a U.S. citizen can then kind of take part in receiving those benefits that have been paid to Medicaid and been paid to the system. And so Medicaid's role really is that they will cover, I mean, they can pretty much cover all of the healthcare costs later in life, so long as you meet their requirements. And so that's really where they can be a very attractive option if things align for that long-term care situation, particularly in the case if somebody needs even, additionally specialized care. My grandmother, she was in a basically kind of a dementia memory care unit wing for 9.5 years. And, that's the kind of stuff that can really bleed a family dry. And so that's really where Medicaid comes into all this, is that they have a set federal, regulation that says this is the amount of assets an individual can have. And that's been stuck right around that $2,000 mark for several years. And then additionally, they can have up to a certain amount in income. And that's really their criteria, in addition to qualifying necessitating healthcare as well. So given what I've just noted about Medicaid and about their ability to pay for these costly expenses on an elderly person's behalf, it can be a very, very attractive option for people who are staring that animal in the face, as far as we may need to, a very common conversation that I have is elderly couple who one of them starts to decline, and there's a limit to how much can be done at home, and in the best cases, the individuals are honest with their family, with their attorneys, with their financial advisors, and if they need help, they're gonna voice that. But a lot of times people will kind of take it on themselves. They'll start doing a little bit of research, which is always kind of makes my skin crawl when it comes to Medicaid, because there is a lot of bad info out there. But one of the consistent pieces that most people tend to come across is this 5-year look back period. And I can confirm for you that is a legitimate thing. And so what it means is that if you are applying for Medicaid, you get down to their asset resource limits, and you then apply. Once it's submitted to Medicaid, they are going to ask for documentation up to the last 5 years. Now, it's kind of like the IRS, where they have an initial questioning form that you have to fill out. And just as I would tell anybody, lie to them at your own peril. But in case you're trying to be tricky, they will ask for records. And so if something looks a little bit wonky, and you engage in what I often see a lot of families do for understandable reasons, but trying to get assets to other family members, trying to get them out of their names so that they can qualify for Medicaid. If that occurs within the 5-year period, that 5-year look back period, and that's from the date of application, if Medicaid catches wind of a, let's say a sweetheart home sale, which in Colorado, that is all the rage for individuals to sell to their family members a $500,000 house for maybe $100,000. I can assure you Medicaid is going to hit you for that. It's really what they look at when a person applies for Medicaid is any sort of transfer that's been done for less than fair market value. So that is a key, I guess, kind of analytical framework to look through any sort of planning that you're doing in advance. Because if there's not a logical argument to be made about why you would do this with any other, random interested buyer on the street, then you should probably at least seek out some additional guidance on it, because they are going to look at they're going to look at the situation with the they basically look at it through the lens of, we're going to try to deny this person Medicaid, because it is an incredibly costly program. And so that's just kind of their MO right now, is they are on the hunt for people who are trying to move assets, shelter assets, and kind of, get between the rules. And so possible penalties. So this is a good chance for some clarification as far as, well, what results if you've applied for Medicaid and they deem that you have made let's say they find out that you put your son on the house that you own. He didn't pay anything for it, but he's now a legal one-half owner of this property interest. Well, Medicaid is not going to come back and go after your son or go after anybody else that you've engaged in, these gifting or these deals with. They are going to go after the applicant. And so how they do that is by enforcing a penalty period. And so what they will do is each state, they have these constantly updated numbers of, and most states are kind of split into regions. And so Colorado, for example, if I'm submitting a Medicaid application on behalf of a client, they have about 4 other counties that surround us, where they take the average cost of long-term care and they use that as a penalty divisor in these cases where gifts have been made. And so I think most recently it was something like $9,000 a month was the penalty divisor for our region in Colorado. And so if I had a client where they had made gifts, let's say they had made $90,000 in, or Medicaid deemed they had given away $90,000 in property. The way that Medicaid looks at it for penalty purposes is they say, well, that was $90,000 that could have been used to pay for your care. Therefore, we're going to enforce, you may qualify for Medicaid, but we're going to enforce a penalty period. So if that penalty divisor is $9,000, they're going to say, hey, that $90,000 that you gave away, that could have paid for 10 months of care. So on that 11th month after you've submitted your application, we'll start footing the bill. Until then, you're on your own. And so that's really where people can get themselves stuck in, between a rock and a hard place, is if they've gifted away these assets in anticipation of applying for Medicaid. Medicaid is not, if you're borderline destitute at this point, because you only have $2,000 in assets, you better hope that you've got a good relationship with the kids and that you're able to get that money back, because Medicaid is just going to say, we don't care how you pay for it, but we're not paying until this penalty period has expired. So really, we could even kind of simplify this a little bit further, and really just about anything that has any sort of cash value, Medicaid is going to treat as an available asset or an income. So, the most common income for, Medicaid applicants is going to be Social Security. Oftentimes annuities are another one of those. Revocable living trust. So the distinction there is just that anything that's held within a revocable living trust, the IRS and Medicaid both kind of treat those assets as the individuals, because if it's revocable and they're a trustee or a trust maker, the IRS, Medicaid, they're going to view it as they have so much control over that asset that we're going to deem it available to them. Retirement accounts, they will assign and states handle this a couple of different ways. But if I have $500,000 in a retirement account, Medicaid is not going, they're going to view that likely, as $500,000 in available assets for determining my Medicaid eligibility. And the real kicker there is that they don't care about the penalty for those early withdrawals. I mean, if you've got, they say you've got to get down to that 2,000. And now I should include the caveat that some states do have a little bit more flexibility with retirement accounts, but Colorado does not. And so I could certainly speak to how Colorado treats it. And if you have, like I said, if you have $500,000 in a retirement account, they're not going to set that aside and say, well, there's built up tax income, and, retirement accounts are very different assets than a brokerage account or, a checking account. And so, another one that surprises people is life insurance policies. If a life insurance policy has any sort of cash value attached to it, Colorado, and as I understand it, most states' Medicaid offices are supposed to treat that as an available asset. So certainly another thing to keep in mind is that if you have, a nice chunky payout that you've been, paying into your life insurance policy for a long time, and you have kind of a low ball cash, I guess, kind of a cash amount tied to that when you're applying for Medicaid, that's going to be a tough conversation that you'll have to navigate, because they will view that as an available asset. They really look at it as anything that you could get your hands on, anything that you could liquidate, anything that you really have access to pay for your long-term care, because it really goes back to that. Medicaid's role is as a payer of last resort. And so the final thing on this list is what's often referred to as exempt assets. And so that is, you can have $2,000 in liquid assets. You can have one vehicle, which, if you ever wanted a good reason to, buy that 911 or that Lamborghini, I didn't tell you to do it, but I'm just saying that may be something to explore. And then a house. So I told Marche before this that these not counted assets, they should really have a big asterisk next to them, because they're exempt for purposes of qualifying for Medicaid. But what Medicaid does, buried in the fine print of these applications, is they have this clawback provision. And so really what they earmark for themselves is, if they end up allowing you to qualify for Medicaid, they determine that, yep, you meet the qualifications, they start paying for this $10,000 a month long-term care for your dad or for your spouse or whoever. That house that they had in their name when they qualified, Medicaid will check the ownership records. I mean, they are very gung-ho about this. Reason that they do that is that if that is in the Medicaid applicant's name and it's in their name at the time of their death, and Medicaid has paid out $200,000 on their behalf, they are a creditor of first priority. And so that is a real kick in the teeth to, now I've never seen them go after cars. Can't say I've seen that one yet, but I have had many people get that rude awakening of, well, we were told by the social worker, or we were told by somebody else that the house was exempt. Well, it is exempt for getting in the door, so to speak, for Medicaid, but there are no free lunches, as most of us know, and so they do reserve the right to recoup their costs paid on behalf of a Medicaid recipient. Now, give you a little tip that is something that we employ frequently, and this is something that goes to a kind of a quirky rule that a lot of people are not really familiar with. There are no penalties whatsoever for gifts between spouses. So what is kind of the best practice as far as that situation where there's a well spouse, there's a spouse who is experiencing dementia or Alzheimer's, and they're getting ready to apply for Medicaid, my usual first course of action is going to be to get the house, which is typically jointly owned by the couple, to get that just into the well spouse's name, because that way, if the spouse who's needing the Medicaid and who's needing the long-term care, assuming that they pass away first, Medicaid would have no recourse against the well spouse, and therefore you've been able to kind of shelter that, what's most people's biggest asset. So yeah, I guess we could just kind of perfect segue into gifting and transfers. So transfers between spouses. Now, this goes back to the importance of having thorough, updated powers of attorney, because if you try to liquidate a spouse's retirement account and you don't have a power of attorney, good luck, because the financial institution, if it's just, it doesn't matter how good of a relationship they may have with the couple and how long they've been working with you, if it's just in the husband's name and the spouse is trying, the wife is trying to access it to cash it out, pay for his care, if you do not have a good, up-to-date power of attorney that allows for that, those financial institutions are going to be very uncomfortable allowing you to do that. And so really there are a lot of options available for kind of the movement, shifting, protection of assets among spouses. You do have to have good powers of attorney in place to be able to do that. But the good news is that as long as you have those in place, you have a lot of flexibility in that regard to planning, because Medicaid does not penalize transfers between spouses regardless of the amount. So gifts to children or other individuals, those are really what I can tell you from experience that any time they see if they're going through the bank records for an applicant and they see any sort of transfers, any sort of checks written to family members, or consistent checks written to third parties, whether it's friends, I have had Medicaid penalize a client of mine for tithing, which is pretty wild. I can tell you that there was another one where I had a grandparent who was helping to offset some of a grandchild's school costs. I mean, like paying for backpacks and stuff like that. So when I say they really go through that with a fine tooth comb, I mean it. And so what you can do to kind of help put yourself in a good position for those kind of circumstances is, one of the things on the slides here is giving away the house for a child caring for a parent. This is a very common situation for families who are lucky enough to have the option. Oftentimes a child will, move in with mom and dad, or they will, quit their job or scale back their hours so that they can step into that caregiving role. Now, that is something that is allowable. It's allowable for compensation. Medicaid allows for compensation to that child. Two things though, if you're considering doing this, number one, have a caregiver agreement in place, because if you're making payments to a child or to a family member or whoever who's providing those caregiver services, Medicaid will allow them, but there has to be a signed agreement in place laying out the terms. So that's one thing. The second one is that if there are certain exceptions where Medicaid will actually allow, in certain cases, the transfer of a home to a child if they meet certain criteria. So last I had reason to dive into the particulars of that situation. Medicaid would allow a transfer of a home to a couple subgroups of individuals. So one would be if a child has provided care for a parent to the extent that it essentially kept them out of a long-term care facility for 2 years, then they will allow a transfer of a house in that situation. Now, best practice in that case is to have a good family physician who works with the children, works with the parents, because the best way to, kind of avoid any issues on that front is to have a doctor signify in writing that mom and or dad needed the level of care that the children were providing, and that it essentially kept them out of a facility. So a lot of this that kind of we're talking about is just creating a paper trail, if you will, so that if you're getting to the point where you're applying for Medicaid on, mom or dad's behalf, you just want to have your ducks in a row as far as your records, and just making sure that, which again, this all goes back to, if you're embarking on this process, first thing that you should do is get on the hunt for Medicaid. And, usually attorneys will hold themselves out as kind of long-term care or elder care specialists, but you just want to make sure that you're talking with somebody who's going to see all these potential minefields and set you on a path that's going to help you avoid those, put you in the best situation possible. Because, it's really kind of like, willingly jumping into an audit with the IRS. You really want to do a lot of planning beforehand, because it is far easier to avoid, the big hiccups if you're just having an attorney that you're able to walk through prior to really kind of starting to pay the daughter for, the in-home healthcare or making any transfers of assets, just it never hurts to get a second opinion prior to engaging in any of those actions. So kind of moving on to the, and we've spent a lot of time talking about Medicaid up to this point, because, that is a huge component to healthcare costs. I mean, it's really kind of part and parcel with how do you protect the family from these drastic and, sometimes crippling healthcare costs. So we've talked to this point, kind of leading up to that incapacity stage, and getting to that point where it's a viable option as far as needing to get some additional help from mom and dad, or a spouse, certainly. But then once they pass, kind of what plays out? Well, if there isn't a trust in place, what you're looking at is going to be the probate process. And so, really, usually the same people who are involved in this whole long-term care planning component, they're going to be the same ones who are then having to administer the probate after death. And so, really, what that looks like is that they would, in most states, you're just going to take the will to the courthouse, notify them of a death, and then you're going to open up a probate matter, which essentially delegates authority to the personal representative, the executor. There's several different names that different states go by, but the personal representative's job is really that administrative role, where whatever it is that dad had in his will, well, now that he's gone, it's the personal representative's job to ensure that whatever documentation he had, whatever sort of designations or gifts or distributions that were in place, that those occur in a timely fashion. And certainly going back to the healthcare side of it, part of the other responsibilities of a personal representative is to ensure that legitimate debts are paid. And so that is something that I always tell, if I'm representing a personal representative, I always tell them to set aside a little bit, I don't know. Usually my go-to is between 10 to 20,000, even after we've made kind of distributions of the property to, the kids or the spouse or whoever, because that is part of their job. Is if sometimes these healthcare companies, they can take a little bit longer to get those claims out to individuals. And if they do have a legitimate debt that needs to be paid, that's going to fall on the personal representative or whoever's representing the estate of the deceased person, because that's really kind of tied into all the state's probate codes, is that that's part of their job as the representative for the decedent, because they're, some debts, they just kind of go away with death. But if you're contracting with a third party, like a healthcare institution, they're not going to go away just because the individual is gone. And so that's certainly something to keep an eye out for if you find yourself in that role after an individual's death.
All right, so I want to go ahead and open up the floor now to questions. And if you can just use the chat box to go ahead and ask your questions, we'll go ahead and take as many as we can. Here's the first one to get us going. So it's not okay. So the question was, is it not okay to move your house into your child's name or quit claim the house to someone else?
For purposes, well, there are a couple different ways to approach that question. So if we're talking at it through the lens of you're anticipating that a lot of time, let's just say that you're doing that in anticipation of applying for Medicaid. So you can always, and I frequently move homes into a revocable living trust, just because there are plenty of benefits, for example, avoiding probate. But there are Medicaid consequences to doing that, and there are tax consequences to doing that. If you are like many of the clients that I've had come through my doors over the years, I always like to ask people, when we're doing this kind of planning, what they paid for their house when they bought it, because that's really what's known as your tax basis. And so I have had people come to me a little bit later than I would have wanted, and they've quitclaimed the house to their son, or they've added him as a joint owner of their home. And that is, if I'm coming into it, talking with them about long-term care, that is a very big problem that they have just created. Because immediately what happens is the IRS, basically the IRS will assign the tax basis of the parent in this case to the child. And so in Northern Colorado, we've seen some pretty explosive appreciation of real estate over the years. And so I've had that situation happen where somebody had been told, well, you need to move the house out of your name. And so prior to applying for Medicaid or looking into long-term care, they decided to add their daughter, they just transferred it, quitclaimed it for $5 to their daughter, who is now the legal owner of the house. Well, if mom and dad paid $80,000 for that house back in the day, and daughter is now the owner of it, it's been transferred to her during mom and dad's lifetime. When she eventually sells that home, she is going to have a massive tax bill, because, again, kind of going back to a situation that I saw recently, if they had just kept it in their name and done some planning where, whether by trust or by will, at the end of the day, the house was passed on to the children after death, they actually will get an adjusted basis if they receive it after that parent's death. So you'll get stepped up to the current market value of the house. Going back to that other scenario where they deeded over the house during their lives to this child, if they take parents' tax basis, it was $80,000. And then fast forward 5-10 years, mom and dad have passed away, and they're selling it for $600,000. They're going to be paying capital gains on $520,000 of profit. That is going to kick your teeth in if you're not expecting it. So really, there's not just the long-term care component, but there's also just that general estate planning, financial planning component of, you may be doing a sort of damage that you aren't even anticipating. And so that's where I always say, before you do anything, just consult an attorney, and certainly an accountant. I love having good accountants involved as well, because they're the experts on this kind of stuff. But looking at it from a long-term care standpoint, you really may be hanging yourself out to dry, because if Medicaid, they get, let's say you don't make it to 5 years, you've made that gift, you've quitclaimed the house to a child, and year 3, you have to apply for Medicaid because you've run out of funds. Well, then you're going to have to tack on a penalty period too. And so you've really kind of gotten all the negatives and none of the positives from attempting to, get the house to the children. So that's something that I always say, do not go to your real estate agent, prior to talking to an attorney and an accountant, because that's one of those doors that sometimes you can't close it afterwards. And so just be very careful, and make sure that whatever you're doing, if you are selling the property, and again, that goes to selling the property. And I just saw, so inherent, I'm just reading kind of an ancillary to that question. So if you do not plan to sell the property or the house, And let's say that a child lives in the area and they're planning to just kind of make that house their residence. If you inherit it, there's no problem there, because those taxes that I was talking about, those only are going to come into play if there's a liquidation event. So if you just live in it, the only way that well, actually, there wouldn't be any problem as far as just receiving the house through a will or through a trust or whatever. It's really just in that situation where it's gifted during mom or dad's lifetime. They're still around. Then Medicaid comes into the picture. That's where Medicaid's not going to come after the child and say, hey, we're going to take the house or whatever. They're going to, mom and dad are going to bear the brunt of that, because they're just going to say, hey, we're going to penalize you because you made a gift for our purposes. And we're going to assess the value of that gift. And then we are going to penalize you accordingly.
Well, we have a few other questions here. The next one that I have is, what are some common mistakes you see people make in elder care planning?
Well, one, and this is through no fault of the client, certainly, because, going back to powers of attorney, I will start by saying that not all powers of attorney are created equal. That is, and the more you're dealing with this incapacity or this long-term care planning component, the more obvious that becomes. So I frequently have people bring in statutory powers of attorney, which Colorado, you could go on Colorado's website, print those out. And I see a lot of attorneys basically just utilize those. And those are usually about 5 to 6 pages. My powers of attorney these days are about 24. Because I want to have the tools in the toolbox, so to speak. You really can't make changes once somebody's incapacitated. And so you got to make sure that whatever you have in place, that they're going to be drafted by somebody who is familiar with this landscape. So following on that, there's no expiration date to powers of attorney. So theoretically, they should be valid for as long as a person is alive. However, what I'm seeing with financial institutions, particularly the big banks nowadays, is that if they are more than 3 years old, they will not accept them. And this is something that is kind of mind-boggling to me, because this isn't something that's talked about. And if a power of attorney, if Chase has a mom and dad's main account, and you're not able to access it as their agent because their powers of attorney are 4 years old, that's a problem. You might as well not have powers of attorney at that point, because you're going to end up having to go to court and have a conservatorship. So that is a practical piece of advice that I would shout from the rooftops if given the opportunity, is that I would say every 3 to 5 years, go and, whether it's the drafting attorney or, a specialist, just have somebody look them over, because that's something that can easily escape a person. And, additionally, just because life happens quickly and a lot can happen in 2, 5, 10 years, I would say, certainly with some form of regularity, go back to your documents and just make sure that they're saying what you believe them to say, because family dynamics, they can change a lot over the years. And so not reviewing the documents until it's too late. And additionally, I would say that this isn't so much a problem or a mistake as it is just an underutilized benefit or proactive planning component, is making sure that the people who are involved, whether it's the kids, whether it's a friend, whoever's going to be stepping into that role, if something happens to you, make sure that they're aware of it and that they know what it entails. One of the things that we kind of, we do flat fees for the vast majority of our estate planning. And part of our flat fees is we offer a complimentary, kind of family or trusted advisors meeting where we just kind of sit down and, it gives me an opportunity to, be the bad guy if necessary, but also I mean, 99% of the time, it's very productive for everybody, because then each person kind of knows how they fit into the picture. It's clear about what is intended. You can do it in a non-frantic fashion, and you can talk about it in a relatively comfortable way, just as far as, hey, nobody wants to talk about their incapacity or their death, but I can assure you, it's a lot easier to do it then while you guys are well and everybody's in good spirits than when you're sifting through the wreckage. That's when that is not the time to be finding out that you've got a whole slew of responsibilities now. And so I would say those are the biggest thing. Certainly, review your documents every couple of years. Make sure that the people that you have listed are aware of it and they know kind of what's entailed. And certainly I always put, multiple cards in, my client binders and stuff, so that if a child lives out of state and I haven't got to meet them, I always want to know who the drafting attorney was, because they would be the first person I'd reach out to if somebody came in and they had a trust from Texas. Well, the person who's going to be most knowledgeable on that and best able to help you kind of navigate that situation is going to be the person who was sitting in the room and talking with the families when these were being put together.
Thanks, Will. Another question for you. When would estate tax affect me, and how could it affect me?
So there are really two components to that. So there's the federal estate tax, which if you have a federal estate tax issue, congratulations, because as of right now, an individual can pass $12 million tax-free in life or at death. Now that is set to sunset in 2026. So a lot of things could happen, but that is where it stands as of today. And so I don't have a lot of people who are bumping up against that. And so again, times that by 2 for a couple. So a husband and wife, they can leave 24 million as of today, tax-free in life or at death. So the federal estate tax is really not a huge concern in most cases. State, there's the state component as well, though. Now, Colorado does not have death taxes or inheritance taxes, but a lot of states do. I know for a fact that Nebraska has and they each call it by a different term, but essentially what it boils down to is there may be a state component where if you live in a state that has inheritance taxes or death taxes, they call them by a couple different names, but basically what it usually looks like is, let's just use Nebraska as an example. I want to say it's something like any inheritance over like $250,000, the state of Nebraska says that for the taxes that you're required to pay to them each year, they have a statute in place that says, hey, anything above this $250,000 that's inherited, we're going to take X percentage of it. So there's the federal component, which most people don't have to worry about. And then there's the state component, which is going to vary based on your location. So I would say, ask your accountant. That's always a good way to look at it. But the good news is that the federal is always kind of the first one that we as estate planning attorneys, that's the big boy, and that's the one that you got to do a lot of planning for. And right now it's just doesn't come into play as often as it used to, because it's been moving up incrementally over the years.
Excellent. Thank you. I have one other question here. Where can I get long-term care insurance if I qualify for it?
So, I think the best place to start certainly would be any, whoever it is that you have current insurance policies with. So if you've got a life insurance policy or even like, homeowners insurance policy or something, I think they're kind of a first good, good resource just to kind of help gathering what's out there. I wish I had I wish I had a quick name to drop as far as a go-to source for this very particular type of insurance, but well, we were just kind of chatting about this before we started the webinar, is that we just don't have a lot of direct involvement with it. Usually when it comes into play in my role is just finding out from a client that they do have an existing long-term care policy. Kind of on that same note, I saw on the text of the chat, what age is good to buy long-term insurance? So again, caveat that I am not an insurance wizard by anybody's metrics, but what I have heard from people in the industry, and again, please take this with a grain of salt, is that really to be most cost effective, you're going to want to do it probably in your 40s or certainly no later than your 50s, truthfully. Just because really I was relaying to Dave earlier that I think that the insurance industry, and you could kind of apply this to everybody, long-term care, given the demographics of the US, has really reached a crest over the past couple of years, and it's going to continue to stay that way for a little while. And so long-term care policies, they're not as widely available as they used to be. And I think that's because the insurance industry got absolutely skewered when they were issuing these policies, when it wasn't as frequent for people to have these long stints in assisted living or in long-term care. And so at least from what I've noticed, they're becoming a little bit more rare. But that being said, I would always start with any existing insurance relationships that you have. Go to them and say, hey, here's what I'm interested in. If you have if you live in, Kentucky or wherever, and you have a long-term care, or kind of an elder law estate planning specialist in your area, they may have somebody good local that you could use. So I wish I could have a good answer of, hey, everybody go to this website and talk to this person, but I just don't. And so I would say, go to your existing resources, see if they can kind of get some options for you. But it's just not as common and not as available as it used to be.
Well, I think that's all the time we have for questions. I did have one that came in really quickly before we a follow-up to if you inherit your parents' home. If they gave you a home and it was over 12 years ago, is that going to incur those?
So there would be tax consequences if you ever decided to sell it, but would there be Medicaid consequences if you were given that house 12 years ago and now mom or dad needs the people who are gifting it to you need Medicaid? No. And this is kind of a good final point to remember, is that just like with the IRS, when you're filling out Medicaid applications, you read those questions very carefully and you give them the information they need and nothing more. And so if they ask you, hey, have any gifts been made in the last 5 years for that gift that was made 12 years ago? My answer is no, and nothing further. Mm-hmm. If it's outside of 5 years, it did not happen as far as they are concerned.
Mm-hmm. Well, thank you so much for that follow-up. And we got to thank you personally from the for the person who asked.
Sure.
I want to thank both Dave and Will for being here. What a very informative webinar we've had today. And we want to remind attendees that you will get a link to the replay of this event, and you're welcome to share that link with friends or family. And we want to also thank the organizations that have made this webinar possible today. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Every financial advisor who has partnered with us has agreed to offer a free initial consultation to anyone we match them with. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much for coming, and we'll see you in another webinar very soon. Thanks, everyone.